Interesting cases that can be taken account of within this description of photography is Bowman versus Fussell, which is a 1978 case, not so old, where the photograph of a bird fight was held to be not original enough, and hence a painting based on such a photograph was held to be not an infringement. Interesting question again was addressed by Associated Publishers versus Basham. This is an Indian case where the Madras High Court in 1964 discusses photography as an artistic work, where the portrait based on photographs will be entitled to copyright if it produces a different result from the photographs and is therefore attributed as an original artistic work status. Then let's discuss other artistic works which include paintings. Paintings seem to be an obvious artistic work. So a painting is an artistic work whether it possesses any artistic quality or not. Similarly, drawing. However, a drawing is an art of representing by line, which is delineation without color or with a single color, and therefore drawing is the noun or the product of such an art. So as per the definition, a drawing would include any diagram, chart or map or plan, and this would safeguard the functional aspect of the work, such as drawings for engineering equipment or even in the present day age what is known as circuit diagrams, and circuit diagrams are therefore considered to be artistic works within copyright law. The case worth mentioning here is the 1974 case of the British Northrop versus Techsteam Blackburn, where a straight line drawn with the help of a ruler was considered to be not a drawing and therefore not afforded artistic work protection. However, one must be a little cautious about and a little slow in excluding drawings from copyrightability, because what is artistic work if not a drawing first? And therefore, a mere score of simplicity should not dismiss drawing within the domain of artistic works as such. Let's understand what cinematographic works are. Cinematographic works originate from the word cinema, and it is described within Section 2F of the Copyright Act, which explains that any work of visual recording on any medium produced through a process from which a moving image may be produced by any means and includes a sound recording, accompanying such visual recording is a cinematographic work. So is this e-tutorial that I am conducting a cinematographic work for you? Does a remake of, say, a foreign language film enjoy the same protection as the original version of the film? Section 2F would not differentiate between a remake of a foreign film if it is an authorized remake. Hence, a foreign language film then reconstituted as a remake would be treated as a new work within the copyright law, and that too a cinematographic work at that. Let's understand what sound recordings are. Sound recordings are different from musical works though. The section defines sound recording as recordings of sounds from which such sounds may be produced regardless of the medium on which such recording is made or the method by which the sounds are produced. So for example, if a channel such as National Geographic actually records bird sounds, then such recording will be afforded sound recording protection within copyright law. However, such recording might not constitute a musical work because they do not have written notations. To ponder, does the audio recording of this e-tutorial again qualify for separate protection as a sound recording? Or can you separate the audio recording, which forms an essential part of this audiovisual as a whole, and then segregate and afford sound recording protection to the to the audio part, while the visual part will be afforded, say, a dramatic work or a performance right to me? These are certain foods for thought for you. So, does a photograph of an already existing photograph enjoy copyright protection? That is, if I take a selfie of my own photograph, if I take a photograph of another photograph on the wall, would that new photograph that I have taken be afforded the same protection as the original photograph? The answer is no. Is a painting based on a scenery captured in a photograph an infringement of copyright in the photograph? Essentially, they would constitute different works because they do not originate from the same author. Are sets of machine-made replicas of the Taj Mahal sold as decor items capable of being protected as works of artistic craftsmanship? The answer is no, because any machine-made replicas do not constitute artistic works within the meaning of copyright law. So that was essentially a description of subject matter requirement within Indian copyright law. Dear students, so we had an interesting module discussion on the subject matter requirement of copyright law. Let's summarize what we've learned so far. We began with the legal provisions of what attributes subject matter requirement. And we began with identifying Section 13A of the Indian Copyright Act describes copyrightable subject matter as being works which are literary, dramatic, musical, artistic, as well as cinematographic or sound recording works. However, we went on to identify that just mere work is not protected as subject matter. There are qualifications for such, and these two qualifications are the originality requirement and the idea that these expressions ought to be expressed in a fixed medium or tangible form. So originality in that sense is then understood further that it does not require to be attributed or analogous to novelty concept within patent law, but is essentially meaning simply that it has to originate from the author. Then on, we understood about the works such as literary works. Not all literary works were understood to be protectable. However, if they are original, then such literary work can be protected. There is no literary merit required for such protection. Therefore, an original work can be protected as literary work. Similarly, an abridgment or a new edition or even a compilation of that original book becomes a literary work within the meaning of copyright law. Similar analogy we found was extended to artistic works. Artistic works would go beyond the traditional concepts of drawings and paintings, but include circuit diagrams, would include photography, would include paintings, and therefore would require to be extensively understood as not being just drawing or painting. Finally, we understood about musical works and sound recordings, again being different sorts of works within the subject matter requirement. Musical works would require notations and written down annotations of what is the musical note as such. Sound recording does not require the same standard. So this e-tutorial, an audio recording of this would constitute essentially a sound recording and not a musical work. And so a Bollywood film would have separate protection as musical work as well as cinematographic works. Cinematographic works are protection given to cinema. However, artistic works or dramatic works do not constitute cinematographic works. Let's understand the dramatic works a little bit more. Dramatic works would include any sort of dramatic incidents, say it's a recitation, a pantomime, a poetry, as long as it has dramatic incidents and those dramatic incidents are scripted. And essentially a point to be taken home is the developing reality TV media these times. They are essentially coming back to becoming derivative rights and not copyrightable work in a sense where TV formats which are non-scripted are not protected as literary, dramatic or even any other form of protection within 13A of the Copyright Act of India. So there we covered all possible works within 13A as long as they are original, fixed intangible medium can then be afforded a life plus 60 years of protection within copyright law. After which, in the event that such term has expired, that work falls back into the public domain for any person to use it, to sell it, to enjoy it, without having to take permission of the author. Thank you very much.